I'm Christopher Nyinevi, the Executive Assistant to Justice Asante at the court. A Moot Court competition, as you may know, is a simulated court proceeding where law students are given a hypothetical case, and then they are required to prepare legal arguments and then present their case to a panel of judges for assessment. And the general idea behind a Moot Court is to test students' understanding of the area of law that is being tested, and also help them to develop their writing, their oral advocacy skills, their critical thinking skills, their ability to make persuasive and ingenious arguments. So all these are important in the training of law students to become lawyers. So the idea behind the Moot Court, as far as the court is concerned, is to also be a stakeholder in the training of the next generation of lawyers in the sub-region. Because lawyers constitute an important stakeholder of the court. They are the ones who present cases on behalf of parties before the court. And to be able to train the next generation of lawyers who will be conversant with ECOWAS law, will be conversant with the mandates of the court, and will be able to present cases before the court needs to be involved in that process of their legal education. So this is a means by which the court can also contribute to the training and education of these young people. By the time they become lawyers, they would have been familiar with the processes of the court, its mandates, and some of the issues it deals with. So the objective of the court in a nutshell, is to one, contribute to the training of legal professionals in the area where the court has its mandate, and to also ensure that we have a next generation of lawyers who can argue cases before the court. So that's, in a nutshell, the idea behind it. But also, additionally, this also ensures that there is a greater dissemination of ECOWAS law and legal jurisprudence. Because in some of our schools in the sub-region, ECOWAS law is not part of the curriculum. So this is the way to introduce ECOWAS law and institutions to the students, and hopefully to also kickstart a process whereby some of the schools may include ECOWAS law in their curriculum, so that it will ensure that we have a next generation of lawyers who are experts in ECOWAS law and can appear before the court and other ECOWAS institutions to assist either their clients or any parties who want legal assistance when it comes to ECOWAS law. Generally the competition has been very successful. The participation, this is a pilot one or an inaugural one, so it didn't include all law schools from the sub-region. But at least with the 8 schools that we have had from Nigeria, they have shown very competitive spirit. And anybody who watched the contest between the various teams would observe that the quality of legal argument and the quality of advocacy by the students was top-notch. In a number of cases, the winning and losing team were separated by a few points. There was actually one instance where the winning and losing team were separated by a half point. And then in this final, the 2 teams were separated only by 1 point. So it shows that there was a very, the students put in a lot of work to prepare, and they did very well in their oral presentations as well. So I think generally feedback from the students, their lecturers, etc., it's been a positive experience for them. And definitely this is something that should be extended to the whole sub-region, so that other students in other law schools in the sub-region can also have the opportunity to participate. Of course, the financial and logistical challenges will be a bit bigger than what we have been able to put into this one. But I think that with innovative thinking, we can be able to do that. And I'm sure immediately after, as we are finished with this now, there would be discussions to see how best we can be able to broaden it to include other law students or other law schools from the sub-region. The competition started with an invitation. Because this is an inaugural one, the invitation was not extended to like all schools in the sub-region. So the invitation was extended to only law schools in Nigeria. They were invited to register. A number of schools, more than 12 I think, registered, but eventually only 12 submitted their written arguments or memorials, as we call it, for the competition. And the memorials were then graded by a team of legal experts within the court, and then the best 8 out of the 12 schools were selected to participate in the oral phase of the competition. During the competition, the rules were explained to the students before we started the competition. We told them how the scoring would be, and afterwards, so we had 3 stages in the oral rounds: the preliminary rounds, in which all the 8 schools participated, and then afterwards we had the semi-finals, where we had 4 schools advancing to the semi-finals, and then the winners from the 2 semi-final contests then faced off in the finals, which was held today. And at every stage of the process, students were made aware of what they should expect, and the results, when they were obtained from the judges after the competition, we had a team of the staff of the court who vetted to ensure that the calculations, everything were correct, and then compiled all the results and then announced them. So everything was done transparently to ensure that there was fairness for all the participating schools involved.